They convicted Gerald Mott of first-degree murder in 1997. Then a paralegal cleaning out a condemned courthouse storage room found a sealed box labeled Mott Grand Jury Suppressed Materials, Do Not Forward, and the cause of death inside it doesn't match the one that sent him to prison. That box sat in room 14B of the Callaway County Courthouse Annex for 26 years. Nobody catalogued it. Nobody subpoenaed it. And according to court records, nobody was supposed to know it existed. Here's what the prosecution told the jury. On the morning of March 9, 1997, Linda Mott was found at the base of the staircase in the family home on Whitmore Drive. The medical examiner, Dr. Paul Erdman, testified that she died from blunt force trauma to the rear skull, consistent with a fall staged post-mortem. Gerald, he said, had struck her first, then arranged the body to look like an accident. The jury took 94 minutes. Gerald got life. The story was tight. The expert was credentialed. The timeline held until the box. Inside the sealed container, the paralegal found three things: a transcript from a grand jury proceeding held 6 days before the trial, a signed statement from a second forensic pathologist named Dr. Catherine Voss, and an autopsy report numbered ME 97441B. That B matters. The report entered at trial was ME 97441. No suffix, a different document. Dr. Voss's report listed the cause of death as acute subdural hematoma consistent with a natural fall. No staged impact pattern, no premortem bruising, just a woman who fell down a staircase and died. 2 autopsies, 2 causes of death, 1 trial. So why did the jury only hear one of them? That's the question the box forces open. And it gets harder to answer the longer you look at the paperwork. Dr. Voss was a board-certified forensic pathologist from the state medical office, brought in specifically because the county examiner, Erdman, had drawn scrutiny in 2 prior cases for overstating injury patterns. She was the second opinion. She was supposed to be the check. Her report was completed on March 14, 1997. The trial began March 20th. There is no record that the defense attorney ever received it. The chain of custody, that's the documented trail showing where evidence goes and who handled it, shows ME 97441B logged into the district attorney's office on March 16th, signed for by an assistant DA named Robert Callis. After that, the trail ends. No transfer to evidence, no disclosure to the defense, no appearance in the trial record. Just a signature on a routing slip and then 26 years of silence. But the second autopsy wasn't even the strangest part. Inside the same box was a handwritten note, 2 lines on district attorney letterhead. No date, no signature. It read, Voss findings inconsistent with theory. Do not forward, file separately. That phrase, file separately, is not a legal designation. It appears nowhere in Callaway County's evidence protocols. It is, by every procedural standard, a fabrication. Someone invented a filing category that did not exist in order to make a document disappear. Now here's where the early detail comes back. At trial, the defense asked Dr. Erdman directly whether a second forensic opinion had been sought. He testified under oath that it had not. He stated that the county conducted a single examination and that he was the sole pathologist of record. That testimony was given on March 22, 1997. Dr. Voss had signed her contradictory report 8 days earlier. Erdman knew, the DA's office knew, the jury did not. Gerald Mott has maintained his innocence for 26 years. He filed 3 appeals. All 3 were denied. The third denial in 2009 specifically cited the completeness of the forensic record at trial, the completeness of a record with a document missing. Now here is the part that flips everything you thought you understood about who had the most to lose. Dr. Erdman did not work independently. He was under a performance contract with Callaway County, renewed annually, directly tied to the conviction rate in capital cases he testified in. If his findings were contradicted and a conviction fell, a contract review clause was triggered. He had a financial stake in Linda Mott's cause of death. That was never disclosed to the jury. It was never disclosed to anyone until a records request filed in 2023 pulled his contractor file. Robert Callis, the assistant DA who signed for the Voss report in 1997, was elected district attorney of Callaway County in 2001. He held the office until 2019. He has not responded to interview requests. His attorney has described the storage room discovery as, quote, a clerical anomaly. The Mott case has been referred to the State Conviction Review Unit. That process takes, on average, 4 years. The box is now in the custody of a public defender's office in a city 200 miles from where Linda Mott died. And somewhere, there is still a courtroom that issued a verdict based on one autopsy. A verdict that has never been vacated. A man in a cell who has now read, for the first time, what a second pathologist concluded 26 years ago. The question nobody can answer is the simplest one. If me 97441B showed a natural death, why did someone need to make sure it was never found?